So I've sued Oracle more than a few times in my career. What I want to talk about today is the lessons learned and what you can expect if you're going to go down that same path. My name is Marcus Harris. I'm a software and technology lawyer. I've devoted my career for the past 20 years to drafting and negotiating software-related contracts and litigating failed ERP projects in courts across the country. Oracle has a reputation for being aggressive. There's an old joke in the software industry, what does Oracle stand for? And it's really true. Their salespeople are motivated by commissions and they are rewarded for selling software, and this leads to software that is oversold and misrepresented. They negotiate their contracts aggressively and they rarely provide meaningful concessions, and the practical impact of that, if you're going to think about litigating against Oracle, is really that your contract is worse than you think it is, and it's not going to provide you with a lot of remedies or a lot of options in the event of litigation. If you're going to litigate, you really need to make sure that that's what you want to do. You need to treat, in my view, litigation as a last resort. The cost of litigating is probably going to equal the amount of money that you spent on the project. It is going to distract you from your everyday business. You're going to be paying, attorney's fees. You're going to be paying for court reporters. You're going to be attending depositions. Your employees are going to be preparing to be deposed. You're going to spend a lot of time in the litigation process, and I think usually that time can be better spent focusing on your business, or ideally focusing on right-siding that project. And I think the other takeaway from this really is that before you go down the litigation path, you really want to do everything you can to right-side that project. Your ultimate goal really is to have a software product that works for you, and I think whether you can get there or not is going to depend on a variety of factors. And when you're dealing with Oracle, there's no guarantee. I think you highlight problems or issues with the software, and I think they have a tendency to be pretty dismissive. And it's not always in your control whether you can right-side that project. It takes two to do that. And if Oracle is unwilling to work with you, then litigation may be your only option. Before you embark upon suing any ERP vendor, and I think Oracle in particular, you need to ensure that you have a good case. And what do I mean by that? Really, you need to have some sort of objective failure of the software to conform with a warranty obligation or some objective standard, whether that is the software is not complying with generally accepted industry standards, it's not complying with a user manual, it's not complying with documentation. You need to have that spelled out, and it needs to be relatively objective. What you don't want to do is initiate litigation because the software doesn't work the way that you expected it to work, or because you're making an assertion that Oracle promised that the software was going to do something that it doesn't do. Those issues need to be vetted out incredibly carefully. An attorney needs to go through those in detail and make sure that they are viable allegations. One of the first things that Oracle is going to do when hit with a complaint is they are immediately going to file a motion to dismiss the complaint. The motion is going to be based on a variety of legal theories, and one is going to be that the lawsuit or the damages that you're seeking to recover is precluded by something called the economic loss doctrine, which essentially prevents you from getting a recovery in both contract law and tort. They're going to assert that any allegations of fraud have not been pled with the requisite specificity that the law requires. They're going to make an assertion that any allegations of breach that you have asserted in that contract don't read on whatever their contractual obligation is. They're going to say that the contract functions and you can't actually point to any kind of objective criteria or warranty that has been breached. And that's probably, there's going to be some truth to that. You've got to make sure that you've got experienced counsel that knows how to navigate those waters and understands what you are up against. You've got to be prepared for Oracle's aggressive tactics. I think it's unlikely that they're going to settle on a monetary basis, at least early in the process. it is more likely that they're going to litigate against you aggressively. They will hire one of the biggest law firms. They will hire one of the most expensive attorneys at that law firm to represent them, and they will bury you in paperwork and discovery and responses and depositions. And it's going to be a long and drawn out process. And I think the reality is, you don't sue a major corporation like this that has a reputation for being aggressive without an understanding that you're going to spend money, that you need to be equally aggressive, and that it is going to take a long time. That's just what you're in for. A lot of clients will believe that they can assert fraud claims and that's going to intimidate Oracle. It just isn't. Oracle has been through this. They've seen this show multiple times, and standard kind of allegations like this aren't really going to do much for them. They're going to be dismissive. They're not going to want to work with you. Certainly on the front end, their attorneys may or may not be reasonable. They may be difficult to deal with. They may increase costs by certain gamesmanship and the like. And that's really just kind of par for the course. So the reality is that when you're going to initiate litigation like this, the cards are going to be stacked against you. And the takeaway from this video really is, you've got to have some sort of objective failure. You have to be able to point to something that Oracle misrepresented, that was an important piece of key functionality that you made known to them before you entered into the contract. You have to be able to point to some sort of failure of the software to conform with the warranty obligation. You've got to be able to point to some legitimate breach that Oracle committed with respect to the contract. Their services were deficient. The consultants they had were inexperienced. They were incompetent. They weren't showing up. They misrepresented the cost of the software or the implementation. These are the types of allegations that you're going to want to make. And I do think that, again, the cards are going to be stacked against you. It's not going to be an easy road, and you have to have experienced counsel. We have done this multiple times, and we've had success in coming to a resolution, and we understand the lay of the land. We get alerts with respect to new lawsuits that are filed. We review them. We understand the causes of action and the various defenses, and you need to have somebody like that on your side. This is not something that you can do without going full steam ahead. You really have to throw the money and the resources and the time to get out of this with a good solid result, whether that's a settlement that provides you with a monetary component, or if there is a basis where you can settle, where you're getting additional software, additional services, if that's something that's feasible. Settlement, I think, is really the path forward here. Ideally, you don't end up in a trial situation, but if that's what it takes, that's what it takes. If you have any questions about the issues in this video, please feel free to reach out to us. We'd love to talk to you and point you in the right direction. You can find us at taftlaw.com.